Here's another really good example of where mediation of a relatively small tenant and neighbor dispute resulted in a successful outcome. And this comes to us from Habitat, which is a publication for the New York City co-op and condo industry, right? And the headline, obviously, it's right on point. Mediation beats litigation. And I love this little graphic. It shows a mediator as a facilitator between two parties, showing where it makes puzzle pieces fit together. And that's key because in many cases, the dispute that two people have or two parties have may not be as far apart as you think. There may be one or two sticking points that seem like they're big deals, but usually they're not. We'll see that in this case. Going to court over a nuisance issue is time consuming and expensive, and this is a noise dispute that was handled with mediation. There were two neighboring tenants who couldn't reconcile the differences. One complained about the other making noise, talking on the phone, and their dog barking. As a result, that party would bang on the wall and slam the compactor chute loudly. So now both people had to listen to noise, right? And they both complained to the condo board that neither one of them was doing the right thing. And so the condo dispute resolution assigned the case to a mediator who met with the parties and spent a full day arguing out and trying to find a common ground. There was an agreement signed by both parties and enforceable in court, called for a number of steps to be taken. Now keep this in mind. The agreement was signed by both parties and enforceable in court, but the parties created this themselves. It wasn't the court saying, here's what you have to do. Because as you know, you've heard this many times and attorneys will tell you this, when a court gives a verdict on a case, usually both parties don't like it, right? Nobody wins. When there's a verdict in the case, both parties are unhappy. That's when the court knows it gets it right, when both people are not happy. So in this case, with any mediation, you create the result yourself, so you have a say in your happiness. In this case, the dog had to get barking training. There was a trainer recommended. Both parties had to put up soundproofing on the wall in between them. There would agree to be no more banging on the wall. The co-op paid for the soundproofing, and it eliminated both parties having to sue, which would have ended up in Supreme Court, would have been 5 or 6 years before that case going to trial. Why is that bad? Well, during that 5 or 6 years, both parties are going to have to hear banging and barking. This ended it, right? Plus the legal fees. Plus it was quick, private, and confidential. We'll talk about why that's important too. Are there other downsides to litigation? Yes. Lawsuit would be a public issue, meaning no confidentiality. So both parties, all of the facts that are said about them and they say about the other person are now in public record. So even if 5 or 6 years later you have some other dispute or job application or a contract and somebody's doing searching on you through Google or online, they're going to find this lawsuit. And if the other person said Joe Schmo is a jerk, that's going to show up. And they might say, well, even if it's not necessarily proven, this person was in this big lawsuit, right? It can affect future decisions about you. Even though there was no suit for money, an insurance company might have to pay for your legal defense, right? So that could end up being something that affects your insurance rates if you have an insurance company that kicks in. Even if you don't have insurance, legal fees for a typical case like this could be $60,000. This is a very good estimate. We've seen many legal cases where the amounts for a very minimal discovery, depositions, pre-trial is 50, 60 grand, even before you walk into court. So this makes perfect sense. And insurance companies, if they pay it, are going to put it into your rates. And if you're a company, it'll be on your loss runs. So when you get a renewal, that's going to be on your loss runs. So mediation does not have to be reported to insurance in most cases. The question is, how do you ensure that these kind of disputes go to mediation? Well, if you're a party to a case and you want to do mediation and the other party doesn't, it may be something where you have your attorney or mediator or even the court show the advantages. There's no downside. Any party can walk away from mediation at any point. There's no obligation. And you're also not forced into accepting the result. Now, if you go to arbitration or you go to court, sometimes it's binding, where if an arbitrator or a judge says, here's what you have to do, you have to follow that. Mediation is this, right? We saw the picture at the very, very beginning. This is what mediation is. A mediator is trying to connect the two parties. They don't succeed until that connection's made. And it's not binding. It's voluntary on the parties. So this is another good example of where these parties avoided 5 years of noise, banging on the wall and barking. They avoided 50 or 60,000 in legal fees. They avoided public airing of their dirty laundry, and they had a result which was mutually beneficial to all parties, and they got the condo board to kick in. So use this resource, even if it's not required in your contract, as an option to divert you from throwing yourself into the lion's den of court where you have no control over the outcome.